May it please the Court, my name is Scheltema, S-C-H-E-L-T-E-M-A, initials L-K. Your Honour, I represent the Pascoe Vale Bombardiers. We are undertaking to compete in the Australian Football League and consider it of the utmost importance that our players be in top physical condition. We are agreeable to using supplements to assist in the achievement of this, but of course without contravening the rules of the Australian Sports Anti-Doping Authority. It was clearly made known to the plaintiff that this is what we sought for the contract to accomplish, and therefore written terms were included in the contract to that same effect. Obviously, however, the circumstances have now changed in a way that makes the goods contracted for inappropriate for use by my client. Your Honour, we make the following submissions. Firstly, we submit the outcome be that the contract is deemed void due to frustration in the form of supervening illegality. Legislation has now intervened, and the purpose for which my client was obtaining the goods is now considered illegal. If we look to the test established in Cadelpha Construction Pty Ltd and State Rail Authority of New South Wales, in the Common Law Reports of 1982, volume 149 and commencing at page 337, we can ascertain the contract has been frustrated because the necessary requirements as outlined in this test are all met. This case states, frustration occurs whenever the law recognises that without default of either party, a contractual obligation has become incapable of being performed, because the circumstances in which performance is called for would render it a thing radically different from that which was undertaken by the contract. Your Honour, supervening illegality provides that a contract may be frustrated after the time of formation where the performance of contractual obligations becomes illegal, just as is in the case with my client in Elite Performance. This has resulted in a total failure of consideration. Common law provides that where the law changes subsequent to contract formation in a way that prohibits the performance of one or more parties' obligations, the contract should be discharged. Therefore, our respectful submission is that the losses caused should not be borne by my client, and the outcome should be that Your Honour orders the contract to be discharged. The plaintiff's claims should be dismissed with legal costs being paid to my client. However, if Your Honour is not persuaded by that argument and is not minded to grant my client the relief that I have asked for in this case, then I submit that the next best way to view this matter would be as a matter of breach of an essential term. The condition breached was one providing that only supplements acceptable under the rules established by the Australian Sports Anti-Doping Authority were to be supplied by Elite Performance to be used by the Pascoe Vale Bombardiers. Elite Performance have breached the contract by supplying a product that is in fact a performance-enhancing substance which is prohibited for use by elite athletes. Although Ultra Zenith may be suitable for use by those who are not elite athletes, the contract between Elite Performance and the Pascoe Vale Bombardiers was specifically formed on the basis the supplements provided would be legal for use by professional AFL players. As established in the case of Associated Newspapers Ltd and Banks found in the Common Law Reports of 1951 at volume 83 commencing at page 322, the test of essentiality inquires as to whether the term appears of such importance to the contract as a whole that the promisee would not have entered into the contract unless they were assured of strict performance of the promise, which ought have been apparent to the promissor. Your Honour, it was made clear to the plaintiff at the time of contract formation that my client would not have entered into the contract unless they were assured of strict performance in this regard. Further mention should also be given to the Australian Consumer Law. Section 55 provides that a supplier should guarantee the fitness of a product sold to a consumer for any disclosed purpose by the supplier. My client expressly made it known to Elite Performance the particular purpose for which the goods were being acquired. Consideration should be given to the original intention of my client and also to the effects that my client were going to experience from the non-performance of the contract. The extent to which this breach has made any further performance effectively the performance of a substantially different contract has destroyed the main object of the initial contract that was entered into. In accordance with the remedy for breach of an essential term provided by common law, the contract would be voidable at my client's election, allowing them to terminate and sue for damages. However, in this instance, Your Honour, we are only respectfully seeking orders allowing termination of the contract. Unless I may assist Your Honour further, those are my submissions.